Hello and welcome to the School of Business, Economics and Law at the University of Gothenburg. I'm Marie Örninge. I work as event manager at the school, and today we have invited Professor Gregor Noll, who will make a presentation for us, and I will introduce him better in a moment. The school has a large variety of interesting research in different fields, and some of it will be presented on online open events during this fall. So please follow us on Facebook, LinkedIn, and check our website regularly, and you won't miss what's going on next. After the presentation today, it would be helpful if you can help us evaluate this event by filling out a short questionnaire that you can find on gu.se/Handelshögskolan. So we can be better if we can. Now, Gregor Noll is professor in international law and the current holder of the Torsten Söderberg Research Chair at the school, and he has a special focus on relationship of neurotechnology and algorithmic systems to international law. And today he will talk about AI and law. Is it a relation beyond repair? We'll see. The presentation will last about 40-45 minutes. And after that, Gregor will try to answer as many questions as he can from you. So please send SMS on 46700 579 509. You can do it during the presentation, and as short questions as possible, please. So I'm done. Now it's your turn.
Thank you so much. Thanks so much, Marie, for this kind invitation, and thanks to you all for joining us online from your, I don't know, kitchens, living rooms, offices, wherever that might be. I'm trying to keep this fairly simple. Have bearing with me if it's too simple at some times, but I think it's important that we are really moving through a couple of steps, clarifying the concepts we're dealing with, to then see what is at the core of the problem in this relationship between AI and law. So, just to encapsulate the theme, let us imagine this could be a beautiful love affair between the two. Let's see whether it ends up like that, or whether there is, as in many love affairs, a fair amount of tension at some point in time. Now, if you, after this event, want to read on, let me be a bit selfish and recommend the work that a couple of good colleagues and myself have been doing in the past years, that has resulted in a book on war and algorithm, edited by Max Liljefors, Daniel Steuer, and myself, out with Rowman Littlefield in 2019. Now you might think this is about war, and I want to talk about things beyond war. I want to talk about AI at large. I think many of the arguments that we are developing here are applicable to the civil domain as well, which I will talk about today. So I'm not talking about war in particular. I'm talking about AI at large, in particular in relation to the law. Now, contemporary legal rules, you might be aware of that, are not really resonant with digitalization, big data, and artificial intelligence. This much we hear from developers and persons working in the industry, that they are, well, experiencing quite an amount of friction from legal rules, from the legal field, when they're trying to push for innovation through these new technologies. So we're hearing from the technology side that law is not always accommodating innovation. On the other hand, we see that legal researchers and lawyers at large feel that the tools that they are handling, the law, is not always making an impact on AI, digitalization, big data in the way we as lawyers would be used to from other fields. You see, I'm identifying myself with the lawyers at this point. Now, we have these two groups questioning each other and each other's tools. And our task now is to understand why that is, why there's this experience of friction, why there's this questioning, and why the law might indeed be lacking traction when it comes to regulating AI and digitalization. So this is the question: is it really a beautiful relationship, or do we have to modify our account and qualify it? Now, let's start with a clarification of the terms we're using. I've been talking about AI and laws related to each other on a kind of a broad and uncomplicated way. Probably we want to break that down into subcategories of sorts. And I'd propose three. I'd propose that we start talking about what is called tech law, and I'll explain in a minute, then move on to what is called legal tech. Many of you will be well acquainted with these concepts. I'll explain them anyway. I'd like to add a third one in a minute, and that is an invention of my own, so to say. That is law by tech. So we have three different fields here. What are they all about? Let's start with tech law, the first one. Now, this is simply something where lawyers are dealing with questions that are coming up through the use of novel technologies, in this case, AI, big data, digitalization. So as you will imagine, when you are installing a new app on your device and you're accepting the settings, well, this has legal effects in any further conflict you might have with the provider of that app. So you're doing something that is relevant for the law, that might engender a legal procedure, that might make a lawyer or a couple of lawyers busy in the future. So there we are in tech law. Tech engenders questions to the law that needs to be solved, and an increasing amount of lawyers are working with those questions, which could be in the field of contract law, they could be in the field of intellectual property law. There's lots and lots of law engaged. And think of the current case dominating the news, the question whether the US administration is going to prohibit the Chinese-owned app TikTok by November or not. If it is acquired, if its American operations are acquired by an American company before November, it will not be prohibited. And if that's not the case, it will be prohibited. That's administrative law at its most muscular. Oh, here we're really seeing that whatever power technology develops, there's always the superpower of the US, the superpower of the state that can flick a switch and regulate technology in a very tangible way. We could also think of further examples. I let it rest here. This is enough to realize that the law still plays quite a role in the technology field. It's not the case that technology dominates law in that field. It's rather the opposite. The law enjoys supremacy over technology when it comes to tech law. Then there's the second category, legal tech. Things are a bit different here. Here the thinking is, okay, imagine yourself working in a law office, doing menial tasks over and over again. Couldn't somebody please invent an application for that? Couldn't somebody please invent a way to automatize this process that is driving me crazy when I have to do it over and over and over again? That's quite understandable. And yes, there are people, companies, operations which are trying to automatize legal footwork. For example, the collection of relevant cases. For example, the sifting through thousands and thousands of contracts that a company might have entered into. There are a lot of fields where you can make good use of, for example, machine learning, for example, natural language processing. And there are numerous companies the numbers are growing, that are actually offering to help here. Now, there are studies about the impact of legal tech on on law firms and legal businesses that are suggesting that some 40% of jobs in the legal field are at risk through automatization by legal technology. That's a 2016 Deloitte study which is claiming that. But there are also people who are claiming, wait a minute, on the lower end of the market, you're actually adding a lot of clients because technology enables a cheaper offer. It enables to cut. It enables us to cut down on human labor, and therewith reach clients that otherwise wouldn't be able to afford our services. So you lose some, you might gain some. It's not necessarily the same jobs that you are gaining in comparison to those that you're losing, but there is a fair degree of fluidity we can expect. Are we already at this point where, according to the Deloitte study, 40% of the jobs are being lost? Well, here I have a quote to you from Nori Becker, the CEO of Law Geeks, which is a platform, an AI platform for legal contract review, who said in a 2018 CNBC interview, "It's like the beginning of the beginning of the beginning." I continue the quote. "Legal," he said, "legal right now, I think, is the place that other industries were 10, 15 years ago, like travel." So the law, he is suggesting, is really moving very slowly, is lagging behind here. We are only at the beginning of the beginning of the beginning of the potential of legal technology being realized. Later on, we'll look at whether that's an advantage or a disadvantage. Right, so we've covered the ground in tech law and legal tech, and now let's go to law by tech. Here, I think we have to adopt a bit of a more long-term perspective. Tech as law is about AI and digitalization fostering human behavior in a step-by-step, incremental, slowish way over time. Think of, for example, yourself performing a search on a search engine, and it returns a certain number of hits. You're performing that search again at a later stage in time, it returns the same, roughly the same number of hits again, the same top hits. You're recognizing that, well, certain of these hits are actually ranking very high over and over and over again. Wouldn't that leave an impression on you that, well, perhaps these hits are more relevant? They are perhaps indeed the top hits. Because questioning their relevancy would mean questioning the search engine technology. And my God, the search engine makes your life so much easier every day. At work, at home, you're not really, you don't feel stimulated to question that facilitation of your professional and private life. Let me change the example. Let's move to the health sector for a moment. Let's think of an application in a hospital that assists health professionals to evaluate X-rays, images of the human body. Let's imagine that such an application consistently suggests a certain diagnosis for a certain state of the body to be found on those pictures. Would we be really surprised if doctors came to see this as a place to begin with, as having some authority? Because after all, this system was acquired after due process. It is operated over a longer time. It assists doctors and other health professionals in their daily work. Why would we question its authority? Another example is actually from legal technology, the legal technology field. Imagine a lawyer at a law firm using a legal tech tool which consistently returns a certain number of cases as the most relevant for the legal question, the legal problem a client is having, would we be surprised if that lawyer would give advice based on those cases that are consistently returned? You see where I'm getting at. This is building a sort of custom. This is building something in us where certain repeated actions, a repeated conduct comes together with a conviction forming in our head, well, that is actually, that action, that conduct is based on something normative, on some rational form of normativity, and we're accepting it for that reason. We're actually building our own professional or private life on it for that reason. And now you'll realize where I'm getting. The technology we're talking about is not limited to single settings, a single law office, a single hospital, a single person searching the internet with a search engine, but it's present all over the world. It is not limited by domestic borders. It has an immense potential to spread around the world, and it does just that. And with it, these kind of law by tech customs are also spreading, and the costs of checking out whether the conduct mandated by law by tech is actually based on rationality and is sound, that's actually quite a hefty price tag to check it up. But let me give you an example where people have checked and found the technology to be actually in conflict with the law. Take discrimination. This is something that the law prohibits in various forms, international law, domestic law. And if AI is found to discriminate in some way, we really have a very hefty conflict cooking up between AI and law. And I have two examples for you. You might be aware of them. There is the rather well-known example of a system, a decision support system used by the US criminal services when deciding probation. The system was called Compass. And researchers found out that Compass consistently produced advice that actually put black people into a less favorable situation compared to other minorities and the majority. So Compass worked in a way, gave advice in a way that actually fostered discrimination. Discrimination is prohibited by law. So you see, here's a real conflict between technology and the law. And it could be averted because researchers took the pains to check out how that particular application worked and which effects it produced over time. So it's a costly process, it's an arduous process. You are not doing that easily by way of routine. And you could say the damage was already done. There had been black people experiencing in their own life the negative effects of that software. There's another example which is recent. If you are following UK media, you will be aware of the fact that over the summer there has been an enormous scandal about algorithmic grading in UK schools, where a software assisted, advised on grading in a way that actually struck against pupils from poorer families. Again, something that, after thorough analysis, can actually turn out to be discrimination. Prohibited by law. Again, we're having a very real conflict here. So, if you just look over these three again, you'll see that in law by tech, you see that it's tech which dominates or which risks to dominate. At this end, tech law, we said, well, actually here it's law that is dominating, that is still supreme. So you have this kind of tension built up here. law and tech both develop normative forces, and there's a kind of a domination game unfolding here. And if you followed me up to now, you'll see that it's still the question where legal tech is going. Is it dominated by law? Because humans remain on top and they are careful to scrutinize any advice rendered by technology. Or is it the case that it pulls more towards the tech side, that it creates habits, customs through technology that are, in a sense, overriding the law? Because you can't carry on your life always checking up whether the technology you're using might unfold discriminatory effects. That wouldn't be cost effective. So here we are. We are having these three fields. I hope I've defined a bit what I'm talking about. Let me add now something that I have a bit more knowledge of because it affects my own work as a researcher at a university. And that's legal research, which is now also experiencing the entry of legal tech. We're also seeing that the number of articles, books that are written with the help of algorithmic research is on the increase, and this stuff is interesting, it's controversial at times, and let me just run one example by you which I personally find it to be very impressive. The question is really, asked by this research is a hard one, and it's directed to the work of judges and other legal decision takers. Here it is. Can we predict the final outcome of an asylum case just by knowing who the judge is, just by knowing the name of the judge? That's a tough question. Lawyers want to be predictable to a certain degree, but they don't want to be too predictable because there are these hard cases where you have to apply a lot of judgment. So if you want, judgment is at the core of producing justice, which is what lawyers at some point of the process aspire to do. Now, there is a piece published by 4 researchers, Dunn, Sagan, Sirin, and Chen in 2018, based on machine learning, which studied some 21 million records relating to some 800,000 asylum cases in the US. So the number of documents studied by this machine learning process is staggering. No team of researchers could have done that in a reasonable amount of time. And they confirmed that actually the judge's name plays an overarching role. Only by using information on the identity of the judge dealing with the case and the applicant's nationality, the algorithm they used could predict the outcome of the asylum case correctly in 80% of the cases. So an accuracy of 80% just by knowing the name of the judge and the nationality of the asylum seeker. What is missing here is the account of the asylum seeker, the evaluation of that account in what we call evidentiary assessment by the judge. So the algorithm knew nothing of that. Nonetheless, it returned a prediction of the outcome correctly in 80% of the cases. So where does that leave us when outcome variations are when predictability is so high, you're wondering whether this kernel of producing justice, evidentiary assessment, has any role at all. Are we doing the wrong thing as lawyers? Isn't the case already decided by being assigned to a certain judge and the asylum seeker having a certain nationality, or decided to a very large degree? So you can probably feel the pain that judges and lawyers at large are feeling when confronted with research like that. What AI tells us is that judges may be all too subjective. And we have this idea that we are not. We are probably subjective, but at a reasonable level in moments where this is actually a sound strategy to produce justice, but not at the levels that the study by Dunn, Sagan, Sirin, and Chen from 2018 suggests. So, hard questions asked by AI to lawyers and their profession. But then again, why should law be any better off in that regard than, for example, the finance industry, where quants are, depending on who you ask, either capture much ground or wreak much havoc on the finance industry? Or think of something more academic. Think of the discipline of history, where quantitative history has entered, and by means of organizing big data sets, tries to deduce cyclical laws of history. It's completely at loggerheads with the traditions we have in the discipline of history. So there are processes going on that you could very well describe as revolutionary, because they're based on really conflicting accounts what that particular field is and which should be its preferred methodology. So let me return to law, though, and let me try to explain why I think that AI really brings about a rather deep-reaching conflict here with law, and one that might indeed be beyond repair. So, just hedging my bets a bit, when I said that AI is a challenge to law, AI may indeed be entering into a relationship beyond repair with law, you could very well say that, well, yes, AI is bringing a lot of challenges, a lot of innovation, a lot of change, but it's a bit like, you know, the old metaphor of the water of a river constantly renewing itself, but the river being still the same. Couldn't it be the case that the law is still the same in its rudiments, its principles, although technology brings changes to the water flowing in that river, which is, by the way, has done all the time. Think of industrialization, which really brought a process of change to law, but didn't undo law at large, or did it? Now, I think here, let me be clear, that AI, if we further go down the road of moving technology into law, means radical change to the law. I don't think that the river water metaphor applies here, but something really epical is going on. And we might be just at this interesting threshold between one epoch and another. So the same power that allows us to denounce bias in, for example, asylum decisions, the same power might pull the rug beneath law itself. And that's the question whether we want that to be the case and whether there's any middle ground we can occupy. Let's try to think about that. But let me first set out what I think are the sources from which this conflict is fed. And let me try to create some space first for doing that. And this is the number for the questions. You don't forget that. If there are any questions popping up, you send an SMS to that number, and we'll try to answer that question either here or in the following. Now, this is harking a bit back in time. So please, wherever you are now, give me all your attention now. What I'm trying to say now is really important, at least to me. Think of the history of monotheism now. Think of monotheistic religions. Think of a history that spans a couple of thousand years. How has law worked during all that time. I'm really zooming out now, and please do follow me in zooming out. How has law worked? Well, one very simplified account could be that the law was given by an authority, divine at first, secular now, was given by an authority to humans in written form. So we are handed as humans a law, and we are tasked to read it, to study it, to understand it, and then to move into real life and to live by it. So you see, it's a very clear, it's a process with very clear separation. Authority hands down law as the term goes. We as humans are receiving it by studying it, by reading it, by trying to understand it, and only then we are moving into real life and we're trying to live by it. And you might add, we are failing, we're moving back, we are studying it anew, and we are moving into life again and trying to live by it better. And that process goes on and on and on. What is important here, though, is a clear separation. The law, when it's given to us, is outside us. We're making it our own by dealing with it mentally, by reading it, by studying it. So there is something here as an excarnate law, to use the terminology by the German cultural theorist Jan Assmann. The law is excarnate, outside our flesh. The very point is to make it incarnate, to bring it inside our bodies, to make our bodies act in compliance with the law. Right. And you might think, well, this is a high-flying example. Think of something very trivial. Think of a business you want to conduct. You want to, I don't know, buy a flat, buy a car, buy a new pen, whatever. And you just want to be sure what the law is saying on that transaction. You're going to study the law. And only then you're setting pen to paper or, swiping your card or whatever you're doing to make the transaction. So there is a clear moving from the law being outside yourself, you bring it inside, and then you act on the world. So, here we are. In simplified terms, excuse my handwriting, we have a divine or secular authority. It works either way. It's handing down law, could be parliament promulgating some law. We have humans studying it, and we have humans trying to live their life by it. Old school monotheistic model being proved to work, well, perhaps not work smoothly, but work over time. Now comes in this aspect of law by tech, the customary effects of technology that I've been talking about a minute ago. AI moves into the field and digitalization, and things turn to be very different. Because what is happening here is that you're tasking this piece of technology to study the world together with you as a human. So you are basically mixing up a human agent and a technological agent in the study of the world. And by the way, I said the world, it's no longer the law. There's something different going on here. At the beginning of the process, you have something like the world. It could be legal cases, it could be x-rays, it could be anything. This is what you relate to in your data set when you are running your algorithm in simplified terms. So you have the world as a starting point, which is studied in a process where a human writes the codes. So a human codes and assigns data, for example, to train a machine learning algorithm here. And then this algorithm can analyze a larger set of data which is what I'm relating to when I'm saying the world. But already at this stage, you are not having this kind of neat difference between the law outside the human and the laws studied by the human. It's all mixed up already in the first step. And then you have a couple of further steps. Hopefully the human decides on the outcome, the results returned by the algorithm, and then there's something we could call the implementation of that outcome, which the human has decided to use in the real world. So it's a process that is starkly different. Here you see a decisive threshold. The law is excarnate, the human is incarnating it. It's not present in a kind of an algorithmically affected normative process that I've earlier described as law by tech. So I'm not saying this is bad and this is good. I'm just saying this is different from this one. And this might account for the fact why we're experiencing this friction, why we're experiencing that the two worlds of AI and digitalization and law do not go very smoothly together. Now, you could ask, could we really source norms and data sets that are supposed to reflect the world, nature, history, reality, call it what you will? Terms and conditions apply, I would say. For one, AI and computer science as large as academic fields are having very lively discussions on their own methodologies. And they're grappling with a problem called the reproducibility problem, which is quite serious indeed. This problem is about one researcher presenting a study with the help of machine learning, for example, describing that study. For that study to be authoritative, it would need to be reproducible. Another team of researchers would need to be able to conduct the same study and engendering more or less the same outcomes. And there's a problem here in the field of computer science, in particular machine learning, where reproducibility is at the core of this problem. And we are finding that there's a lot of normative activity, a lot of guidelines, a lot of talk, how can we do this better? But there's also an acknowledgement at the moment it is not possible to repeat studies done with the help of, for example, machine learning in a way that is more or less engendering the same results. So it's a grave problem. So weirdly, we're seeing that the subjectivity of the judge that the asylum study earlier revealed, are judges all too subjective? Are they not at all caring about evidentiary assessment? Now we're seeing a reflection here. The question is, are AI researchers all too subjective? Are they in a bubble of their own, basically producing results that cannot easily be repeated by another person on the same preconditions? So, crisis is reflected by crisis. I'm fine with that. I'm working in a tradition where kind of a practice-oriented positivist law has been contested for years and years and decades and perhaps centuries by skeptical lawyers, skeptical legal researchers in the tradition of postmodernism and post-structuralism in the past decades. There's always been this kind of conflict about how much you can formalize and how much subjectivity is appropriate in the legal field. We're seeing something structurally similar popping up in the field of computer sciences as well. So that would suggest that we shouldn't invest too much trust into these amalgamations of humans and machines when it comes to studying the world. It is not the case that we have invented some kind of a whiz-kid technology that allows us a shortcut to making hard and fast statements about how the world functions. Right. As there is no longer a separation between code and human study preceding implementation, we cannot just make new laws within our human understanding of what law is and does. So once you've entered into this kind of normative process, you can't just flip back into old monotheistic normative lawmaking, because the two are not easily integrated to each other. And if you just look at that simplification, you'll understand why the limits are set differently, the process is different, and this process can't just be easily subsumed under the old monotheistic process. So this is why I think that AI and law have entered into a relationship beyond repair. Is this a bad thing? I don't know, but think of earlier historical examples. Think back to the 17th and 18th century. Think when alchemy handed over the baton to chemistry. That wasn't a process that was smooth by any means, but neither was it an on-off affair where alchemy one day died out and chemistry took over. So it was rather a layered process where alchemy and alchemical thinking coexisted with the emergence of chemistry and a method of thinking nature that expressed itself in chemistry. There were researchers at that time who were versed in both methodologies, who could use the languages of both alchemy and chemistry. There's even a name for it, chemistry, with a Y instead of an E. Isn't that something that could give us pause and some hope as well? Perhaps it's a good thing that law is so slow, that we're just at the beginning of the beginning of the beginning, as the CEO of Law Geeks had it. Perhaps we need that time in order to sort out the relationship between two normative processes that can't be easily reconciled. And at the end, perhaps this time will allow us to consider whether that we really want some sort of nature speaking to us in the same way as divine authority, God, has been speaking to us over centuries and centuries. I'll end here. There's still space for questions to be asked. We have gotten in the first ones. I'll just remind you, for questions that go rather deep, there's still stuff to read, not only by me, but also by my learned colleagues in War and Algorithm, the book that was published by Rowman and Littlefield in 2019. And of course, the field is much larger than this book, so you can move on and keep the debate alive. So what I'll do now is breathe deeply and look at the first questions that you kind people have sent over to Marie for the time being. All right, are there any reports providing, this is one question, straightforward question, thank you very much. Are there any reports providing that AI is speeding up the legal processes, for example, the due diligence process? If you ask industry, yes, no doubt about that. If you can do work that, well, the lesser paid employees of a law firm has been doing earlier, if you can do that work by means of algorithmic technology, surely there's a potential to speed up things. And that's exactly what the providers of those applications, of those platforms are claiming. And I do think they have a case here, very clearly. I mean, probably we are all using word processors, or we are all using the internet in some way, so we're exploiting technology. Sorry for being so trivial, but the question is, of course, here, what happens in the hard cases that I've pointed to, the cases where something that seems to be just this great time-saving and expense-saving technology returns erroneous results. There, of course, one could say it's not at all speeding up. But once you are encountering kind of a first hint that the technology you're using is not doing a good job, then the going gets really slow and you have to reinvest the time you've saved. So this is essentially what we're talking about. All right. Good. Second question. When do you think it's possible to meet a lawyer through a video meeting in the same way as a doctor today? Well, this is already happening in the corporate world. And I think we all realize it's experienced a huge boost in the past months. But if we are thinking of me going out and wanting to, I don't know, start a business and I want to have advice by a lawyer on how to avoid the worst pitfalls, that's something that you can automatize to some degree. And there are already platforms out on the market today saying, hey, you don't need a fixed relationship to a law firm that you might think is expensive and scary. Come to us just like you would use a platform for selling your old stuff or your old car. Come to us. We are offering a platform for solution where you can do an on-off, one-time transaction. And if we can, we're trying to help you with a kind of a bot-like tool, very simply. But if your answer is just a little bit more complicated, you can meet a lawyer online who is sorting out the pitfalls for you. And after that, we're each going different ways. It's not the case that you're obliging yourself. So these industry solutions already exist, are out there on the market. They are not on everybody's minds, like eBay or other platforms that we're using for buying or selling used things. But I think in a couple of years ahead, that will be the case. They are making inroads into the traditional offering of legal advice. So good question. We're still seeing that process unfolding, but it's not the case that we are only at the beginning of the beginning of the beginning in that particular respect. Right, let me just glance over the next one, whether I am fine with answering that as I stand here, or whether I need to go back to my books. Right, the next one is moving a bit into a domain that I'm not quite versed with, making comparisons between the US and Sweden, America. Those of you, or that one of you asked the question, have some bearing. We'll try to return on that one if I can. Right, the fourth, I think I'll read it up. Can we say that the Chinese social credit system is a move towards law by tech? How will it transform our understanding of the role of law in society? And are there any chances we will have a Nordic or European variety of this in, say, 20 to 30 years? Great question, and that's really relevant to think about. Now, we are not living in a one-party state in Sweden. We are not living under the same political conditions as the people in the People's Republic of China. That's pretty clear. We don't have a social credit system. And it's not the case that states in Europe can move in the same way as government, as the Chinese government. Now, still I think it's very relevant to think about the social credit system, because what if, and that question has been asked before, what if that which is prescribed in a mandatory way by the state is something we are inviting citizens into in a soft way by making life easier in European democracy? So what if we are essentially using the building blocks, the same technology, and allowing that technology to build on each other, but we are doing that in a way which is built on private agents, which is building on data you acquire rather than data you just collect mandatorily? And what if we, as citizens, are enticed, are moved to consent to that handing over of the data? You might think that the building of the system won't be as fast and it won't be as harsh as the one in China, but the differences are not categorical, if you are making it attractive for people to hand over their data in everyday life, and you are letting them consent to the amassment of that data, to the transaction of that data to other actors, you can do many, many things in terms of affecting the behavior of your population in a soft way, in a way that is not too far from the harsher way that the Chinese social credit system acts. So I do think that whether we are there in 20 to 30 years in a kind of a state where the effects, similar effects, are experienced in, for example, European democracies, depends very much on the vigilance of citizens. Depends very much on where we are taking debates about the use of data and whether we can kind of amass users' power as a political force and make it clear to the market that this is important and we are not prepared to have this data used in a way that could rebound on us and that could actually develop normative effects at our detriment. So this is basically a call to political arms as consumers, as users of technology. Now, let me just glance on where we are time-wise. Yes, I do think we have time for another question. And let me just glance over it. Right, this is a good question. Today, I'm reading it up. Today, law enforcement authorities use technology to regulate criminal behavior. For example, the distribution of illegal material such as child abuse material. Could you reflect about the future regarding technological regulation designed with the help of artificial intelligence and machine learning? What dilemmas do you think could arise from this? This is a very good question, because we could also take the case about discrimination that I made one step further and say, what if we have a technology that allows us to protect people from crimes, that allows us to protect people from infringements on their human rights? What if that technology is readily available? Shouldn't the state use it? Shouldn't the state be deemed to be under an obligation to use it by virtue of the human rights obligations that a state has entered to protect its population? And that's a very real dilemma. It's one that takes place within law. It's something that basically law is receiving from the availability, through the availability of that technology. And I do think that the answer that law will have to a question like this, well, what about a technology that both harbors the potential to violate law and be discriminating, and at the same time offers the potential for a much, much more effective law enforcement, including an enforcement of human rights protection of populations. What should a state do in a situation like that? I think the standard response that law would deliver is that, well, this is about proportionality. If we, in a particular case, if you can make a particular case that technology actually, the gains offered by technology are larger than the losses you incur by it. So, I don't know, the harm you are protecting from by using technology is greater than the harm that technology may inflict on your population. If that balance tips to one end, you are actually under an obligation to use that technology. That would be a proportionality assessment. Lawyers are quite used to doing those kinds of assessment, in particular in the human rights field, in the field of basic rights, which is something that is highly relevant when you're trying to think about what strategy you're using in criminal law enforcement. So, yes, I do think there are real dilemmas within law, and you could set the label of human rights on it. There are strategies for resolution. The word here is proportionality reasoning. Not saying these are easy things to do. I'm not saying that lawyers are just great at doing proportionality assessment, but we do have a language for that kind of stuff. And I do think that public participation in those discourses is elementary, because what lawyers deem to be proportionate is very much fed by what is cooking in public discourses. So again, what I think comes out of this is a call for participation in those political discourses. Don't think this is for people insiders to the technology or insiders to law alone. This is actually for everyone, I'd say. Now I see Marie has put further questions to me. I think I'll have to have a look now how much we can deal with in the 2 minutes we have left. Oh my God, this is great stuff. Yeah. Right. Okay, I have 11 questions here, which are all great, and they mandate thought. I'll pick one of them just to make maximum use of the time that we have had allotted to ourselves. And let's pick that one. Number 10, as a student in law or a young lawyer, how do I stay relevant in a world of AI and law? How do I make sure I won't be part of that 40% that will be out of a job? What direction or field should I focus on? That looks like an instrumental question, but I do think there's a philosophical question behind it. Let me try to answer in a way that is both instrumental, prone to everyday use, and that doesn't negate the philosophical background that drives it. So of course, this is the million-dollar question for a law school like ours. How do we stay relevant, and how do we help our students stay relevant? Now, one answer is to basically tell students to become bilingual, to, well, actually make some inroad into that other discipline, computer science, AI, machine learning, what have you. Build alliances, go a course, try to understand statistics on a very rudimentary level. You're not asked to totally change your identity. It's just that you are asked to extend yourself over another discipline. Multidisciplinarity has never been bad in history. So that's the first invitation. Think of whether you can set off a time for a course. Can be anything from statistics to machine learning to programming, whatever. It's not the case that you need dual degree from a start to stay relevant in the market. But I do think bilinguality is an advantage. I'm seeing a certain commotion here. I think we're coming to the end, but I just want to send this one message. When you're trying to educate yourself into being bilingual, don't forget that you have still entered the law for a reason, and that reason was to contribute to the production of justice. And don't let technology override that choice of yours that you made once. Now I think my time has run out.
Yes, it is. Thank you so much, Gregor, for a super interesting presentation. I hope you all enjoyed being with us today. Don't forget to fill in the questionnaire on our website or send an email to me on event@handels.gu.se if you want to give us some feedback. We'll discuss later, Gregor and I, how to respond to more questions, because there are quite a few more that we didn't have time to answer now.
Right. Thanks very much. Thanks to all for joining and listening and sending questions and basically staying within the debate.
Yeah. And we hope to see you again. Bye.
Bye-bye. Tack för blommor.